between Constitution and one law. The context of the word law in Article 13.2 docs not show that it includes an amendment of the Constitution made under Article 368. The Constitution itself makes a distinction between Constitution and law. The functional difference in making a legislative law and an amendment of the Constitution likewise explains the basic difference in the procedure prescribed in Articles I07 to 111 and in Article 368. An expansive construction of the word law in Article 13.2 would permanently rule out the lawful making of structural reforms in CLR's social, economic, and political frame of the country. The Constitution makers must have intended that when a conflict arises between the rights in Part 3 and the obligation of the state in Part 4, that conflict may be resolved by an amendment of the Constitution under Article 36A. The provisions of the Constitution show that fundamental rights may be taken away or abridged for the good of the people. The Constitution makers did not regard the rights mentioned in Part I as sacrosanct or as inalienable and inviolable or asimmutable. The rights in Part I arc down right man-made, Pinzo 3 to 912, State of Madras VSMT. Champakam Dorai Ryan, 1951 JSCR 525, Krishnan v. State of Madras, 1951, SCR 621, and Bashashar Nath, VEI. Commissioner of Income Tax, 1959, SUPI SCR 528, 604, 605 referred to. There are no inherent and implied limitations on amending power in Article 368. The magnitude of the amending power is to be measured by the purpose which it I1 designed to achieve, then by the structure of Parliam CNL. Under the Constitution, some legislative powers are not subject to any inherent and implied limitations, nor can implied limitations be spelt out of the vague emotive generalities of the preamble. The preamble is neither the source of power nor of limitations on power. The scheme of Article 368 is to recreate the primary organs of state and to redefine. RCDC marcate and RC limit their powers and functions if and when it becomes imperative to do so for the good of the people. Accordingly, it must plainly have been the intention of the Constitution makers that Article 368 should control and condition rather than be controlled and conditioned by other provisions of Constitution. The Constitution makers who were familiar with English constitutional history. Supreme Court Reports, 1973, Sups, could not conceivably have left undetermined the test of distinguishing the CI essential features from the non-essential features, or their core. The test is writ large in Article 368 itself. Every provision of the Constitution which may be amended only by the procedure prescribed in Article 368 is an essential feature of the Constitution, for it is more set than legislative laws. The test is the rigid procedure. The more rigid the procedure, the more essential the provisions amendable thereby. Thus, the provisions specified in the proviso to Article 368 are more essential than the rights in Part 3. Article 368 places no express limits on the amending power. Indeed, it expressly provides for its own amendment. It is not permissible to enlarge constructively the limitations on the amending power. Courts are not free to declare an amendment void because, in their opinion, it is opposed to the spirit supposed to pervade the Constitution but not expressed in words. Pine 12 to 919. A.K. Gopalan of the Union of India, 1950, SCR. A8 120. Raya Surya Pal Singh v. State of UP, 1952, SCR.
State of Bombay, 1960 ISCR 905. South India Corporation, PLJDV.
TM Secretary, Board of Revenue, Trivandrum, 1964, 4 SCR 280, 295, and Mangal Singh v. Union of India, 1967, 2 SCR 109 referred to. Judicial Ret 1 Mayu of Constitutional Amendments. From Gopalan to Golaknath, the court has shifted from one end to the other end of the diagonal, from Parliament's supremacy to its own supremacy. At the center of the court's legal philosophy, there is the rational free will of the individual. This philosophy has entailed the subservience of the directive principles of state policy to the fundamental rights. Article 31, 4, 5, and 6 establish beyond doubt that the Constitution makers intended to give ascendancy to the directive principles of state policy over the fundamental rights. The Constitution does not recognize the supremacy of this court over Parliament. The court may test legislative laws only on the touchstone of authoritative norms established by the Constitution. Its procedural limitations aside, neither Article 368 nor any other part of the Constitution has established in explicit language any authoritative norms for testing the substance of a constitutional amendment. Structural socio-political value choices involve complex and complicated political process. This court is hardly fitted for performing that function. Judicial review of constitutional amendments will blunt the people's